Hello, everybody. My name is Kaylee Pugliese with the New England First Amendment Coalition, and thank you so much for joining us for this latest open government lesson. So for those joining us for the first time, welcome. These lessons are part of a growing NEFAC library of classes on public records, open meetings, court access, and our right to record. All lessons are available to view in our FOI guide and on our YouTube channel, 5 Freedoms, and you can find us there with that username. To everybody, please take a moment to subscribe to NEFAC's community newsletter. This is the best way to stay informed about upcoming classes and events, and you can just go to nefac.org/subscribe. But today's presentation is supported in part by the estate of Gloria L. Negri, and Gloria was a trailblazing journalist at the Boston Globe for more than 50 years, and this program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other NEFAC supporters at nefac.org/supporters. And during today's presentation, I again encourage you to all introduce yourself in the chat, share your experiences and your resources, and you can also use the chat and or the Q&A button to ask questions of our instructor, and we'll get to as many of those questions as possible by the end. But for now, let's get started. This is NEFAC board member and ACLU of Connecticut legal director, Dan Barrett. I am just gonna pull up Dan's presentation and then we will get started. Dan, take it away.
Great. Thanks, Kaylee. And good morning to everybody. Apologies, I'm on my phone because of some kind of Zoom mistake this morning, but I'll try to pay attention to everything that's happening on this tiny little screen. So I'm here today to talk to you about the right to record here in Connecticut. We've done a series of these throughout New England. The New England First Amendment Coalition covers all states in New England. And today's Connecticut's edition. I'd like to avoid falling in the trap of just reading a bunch of slides to you. So I'm going to hit a couple of areas, and then I'm hoping that if you have questions or you want to discuss, we can have a more complete discussion rather than me just kind of like reading boilerplate text to you. But we're going to cover a couple of areas. The first is a real hot topic these days post-pandemic, which is open meetings, whether it's possible to record open meetings. So Kaylee, if we could hit the first slide, please, or rather the second slide, I guess, after our intro here. There you go. All right, that's a lot of text. Open meetings, what I'm talking about here is state or municipal meetings in Connecticut government. This is state or local only, not federal. And these are familiar to anybody who's a journalist covering them. They're the same entities that are covered by our Public Records Act. So this is any public agency, any executive, I'm reading from the statute here, I don't have it memorized, executive, administrative, or legislative office of the state, or any political subdivision of the state, which means a municipality. Great news on this sunny spring morning. The answer is, by default, yes, you may record a public meeting in Connecticut. And that's our General Statute 1-226A. At any meeting of a public agency that's open to the public, the proceedings may be recorded by any person. Now, you've got a couple of caveats, as always with the law. I feel like every time I tell people about what the law is, the answer is like, either it depends or it has some exceptions. But there's two things to bear in mind. The first is, while you're there recording, you have to do so, I'm paraphrasing here, unobtrusively. So if you're bringing a camera and a tripod and that kind of stuff, just set it up so that nobody's tripping over it or you're not blocking the view of the meeting itself. The second is the subsection B of that statute, which allows any public agencies to adopt rules governing recording. Now, there aren't any outer limits in the statute to that, but one imagines from the first section of the statute, 226A, that the agency is not going to be allowed to adopt a rule that says, for example, no recording is allowed whatsoever. You might find that agencies adopt rules limiting, so if there's press coverage and it's a small room, they may allocate that space, things like that. If you've heard otherwise, please let me know in our discussion. But the general default rule in Connecticut by statute is, you bet, you can record. Let's hit our second area of your right to record, and that's photo or video of public buildings. That's the next slide, please, Kaylee. So can you record the exterior of public buildings themselves? We'll start with exterior and work to interior. This hardly seems like a topic that requires a good deal of conversation or thinking, and yet I'm currently litigating a case about this. So photography and video themselves are protected by the First Amendment's speech clause. And therefore, we have an older case from the Second Circuit, which is our federal regional appellate court, that protects photography, and it's called Tunick v. Safier. And in the context of that case, it was an artist, a photographer who wanted to close a small street in Manhattan on a very early weekend morning and stage a photo shoot. And the city was all over him for a variety of reasons, one of which is that his subjects were going to be naked. But the Second Circuit had no problem concluding that photography is protected by the First Amendment because it's expression. It's in the same way that I can go to the Wadsworth and see beautiful paintings. I can see photography. I can see video art. Those things are all protected. It hardly seems like the kind of thing to tussle about. Now, I would say the one thing to be mindful of is that if you're shooting the exterior of a public building, you just want to make sure you're doing it in a place that you're lawfully allowed to be present in. So, for example, if the building has a big fence around it, don't hop the fence and then take video from inside the fence and claim that you're totally fine to do that. Stay on the sidewalk. I think the general rule you should think to yourself is something that we import from the Fourth Amendment, which is the so-called plain view doctrine. The rule is that anytime the cops can see what you're doing in public with their own eyes, that can generate probable cause to charge you with a crime. So if you're stealing cars in broad daylight, it's fair game for them to just look over and see you. But the same applies to them. If the building is in public, it's totally visible from a lawful spot, you can take pictures of it. The interior of buildings is slightly different. And here I'm working in a vacuum of Second Circuit law, and I'm extrapolating what the rule probably is or ought to be, and it only gets developed in the case of a conflict, and most times things work just fine. It depends a little bit upon the space and what's going on inside. So the more public the space, the better your chance of being protected if you're going to video record inside. For example, the lobby of City Hall, where everybody comes to pay parking tickets and register to vote and do whatever else. It's a very busy spot. It's absolutely open to the public. There's nothing particularly private going on right there. That's a pretty good argument that you have that you're allowed to video record there. Now, it gets a little different if we're talking about a spot in which people are engaged in private activity. And I use the term private, meaning it's stuff that's really not intended to be exposed to the public. And here I would think about a publicly supported medical clinic, a parent-teacher conference at school, right? Those things they may be places to which you have access, for example, because you're a patient at the clinic or you're a parent and you're attending your child's, parent-teacher conference, but that doesn't necessarily mean that you can record what transpires. And the other courts, aside from ours, it hasn't really addressed this, that have talked about or thought about how the right ought to be delineated really dwell on the idea of public space where everyone's invited. And in those spaces, you're A-okay, but when it gets more private, you start to run into questions of whether there's confidentiality of what's going on inside, there's confidential information, or whether even the identity of the other people in the setting ought to be protected. And here I'm thinking, think about a public library, for example. Typically, the law has been pretty tender, and so are we as Americans, about what we read. We don't necessarily want people knowing what we're reading. It betrays our inner thoughts. Sometimes it can be embarrassing if you're really into, pulpy literature. You may find that embarrassing. And the First Amendment says that ought to be protected to some extent. So you can imagine a library. You can imagine another setting in which you're really not able to walk in and just start videoing. But generally, the more public, the better off you are. So maybe let's go to the next topic, which is related, and it's photo or video of government employees that are in public. That's our very next slide, please, Kaylee. This is where you tend to get, I think lay people may have heard the so-called right to record discussed. This is where you get litigation because public employees tend to get pretty touchy about being recorded. I'm speaking specifically of the police, who aggressively resist any attempts at oversight, even if that's as simple as documenting what they're doing. In our federal regional appellate court, which is the Second Circuit, it covers New York, Connecticut, and Vermont, there is no so-called right to record First Amendment decision yet. But I would fully expect, and I don't think Justin Silverman would tell me I'm wrong on this. People like me and hardcore advocates like NEFAC, I think, would expect that when our circuit gets to the question, they're going to follow every other circuit to have addressed it and explain that there is a First Amendment right to memorialize what can be seen from a lawful vantage point. On some level, you may wonder, well, gosh, I think about the First Amendment or the speech clause of the First Amendment as really only having to do with speaking. And so why in the world would this right to record be located there? And it's typically because we think of speech, which is protected by the First Amendment, as having two components. The first is the expression itself, the speech itself. So the government typically cannot punish you for what comes out of your mouth, absent, certain very, very narrow exceptions. But the flip side of speech is the ability to gather information and material to generate speech. And so, as has been observed by many courts over the years, the right to speak would be meaningless if the government could simply restrict the body of information from which we could draw to generate speech. And so, for example, if the government could prohibit us from reading certain kinds of books or prohibit us from obtaining certain kind of information about what our government is up to, it could thereby limit the amount of speech that we, the people, could generate. And therefore, it's effectively equally protected. So as a result, this First Amendment located right to record deals with your ability to gather information about public employees who are doing their jobs in public. And it also touches on your ability to create or memorialize through some other means what you see with your own eyes. You wouldn't think that the ability to video record something is a topic that could be litigated. It's pretty obvious, I think. But you may think of it as our ability to do something like, let's say I'm walking down the street and I see the fire department responding to a big fire. Now, I don't think there's much question that I would be free to pick up the phone and call my buddy and say, wow, you won't imagine what I'm looking at right now. This is a huge fire, blah, 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 and describe it orally, right? That's plainly protected by the First Amendment. I could also write a note to myself. I could send a voice memo. I could sketch it if I were an art student. I could make a painting. I could do all of these things. I think the same general rule applies to memorializing with video. And as a result, I suspect that when our circuit gets around to addressing the question, it's going to hold that. So your key as journalists, as citizens, your key is public employee discharging their duties in public. As we talked about a little bit earlier, in a private place, there are some different considerations. When the government is out doing its work in public, on a street, whatever it may be, you more or less are fine to record them because they are exposing everything they're doing to the public. Now, there's a Connecticut-specific wrinkle that you may not be aware of in that we have a state statute specific to police that authorizes a lawsuit against the cop's employer if the cop interferes with any person who's taking a photograph or a video of the cop or another cop acting in conformance with their duties, that is to say, doing their jobs in public. That statute was passed in, I think it was 2019. It was part of a package of police accountability measures. It hasn't gotten much road testing, but it's very useful. Now, you notice it doesn't apply to every public employee. So if you're really big into seeing what your DPW is up to, this statute is not going to protect you. The First Amendment probably will, but it's worth keeping in your back pocket if you're a journalist who does a lot of reporting on cops, that we do have a state statute. Sometimes when dealing with the government, it's easier to refer them to a statute than a bunch of case law that sort of may hold X, Y, and Z. It's easier to just open up the book and say, look, guys, it's right here. That may be some help to you. All right, so we've done public employees doing the jobs in public. We've talked about the interior of buildings. I want to cross over and talk a little bit about courts now, which is our next slide, please, Kaylee. As you know, here in America, we love government so much that we have two levels of government. We have state and we have federal. They operate their own distinct court systems. And as a result, we have two separate sets of rules around whether you can photo record, video record, or audio record inside of those courtrooms. So I want to talk first about state court, Connecticut state courts. Generally speaking, whether state or federal, there is no First Amendment right to record inside of a courtroom. And as a result, the individual court systems and individual courts themselves are on their own to determine the rules about when recording is possible. Famously, the federal Supreme Court does not allow anything. They produce their own audio recordings. So in Connecticut, if you're talking about the Superior Court, any of the state courts, the Superior Court, the Appellate Court, the Supreme Court, the background rule is that there's no recording without obtaining permission first. And it takes a little bit of work, but having done it here at the ACLU, we've done it. It's not that onerous. The first thing you have to do is to be designated as, quote, media by the Office of the Chief Court Administrator. I suspect that rule was written in, pre-social media times when there was a pretty clear delineation between media and citizens. But right now, certainly for First Amendment purposes and maybe every other functional purpose, that distinction has kind of disappeared. And I think it's easy to make the case when asking to be accredited that what you're doing is gathering information to disseminate ideas. If you have had problems with that, let me know. We also have decades of First Amendment case law saying that the media, by the way, this is not a popular message for journalists, but media doesn't enjoy any greater access to information than we the people do. So you can get yourself accredited as media by the Chief Court Administrator. And then once you do that, and as far as I know, that's good kind of forever. So you can do that once if you're in the business of covering courts, or if you're a person who's very interested in it, get yourself accredited once. And then when you go in, you're going to go into court to record. You have a couple of different ways of doing that. In the criminal world, the criminal side of Superior Court, you're going to have to give prior notice if you're recording arraignments. In the civil world, the judge is typically not going to let you record any portion of a jury trial in which the jury is not present. And that's because the judge in a civil jury trial will sometimes discuss housekeeping, evidentiary, other matters out of the presence of the jury because they don't want the jury to hear it. Think, for example, an argument over the admissibility of a piece of evidence. If the evidence is unadmissible, you don't want the jury to ever run across it. There's, for both civil and criminal, there's a specific way of notifying the judge that you're coming in to record. I can direct you to that or walk you through that if you're having problems with it, but it's pretty low key on paper. I've done it. And it can be a little free form, but I had one proceeding in which the judge thought it was kind of like just open season to allow the parties to object for no particular reason, but we got to the right answer eventually, so I wouldn't be overly scared of it. It is possible to do. But then we flip over to the federal courts. If you would, Kaylee, the very next slide, it ain't a long one. No recording allowed in federal court. That's that. You may not. Our federal trial court, the District of Connecticut, has a local rule prohibiting it. So does our appellate court, the Second Circuit, and the U.S. Supreme Court, of course, famously does not permit it. So you have to think of another way of getting done what you need to get done. We can talk more if you've covered the federal courts a lot. I mean, audio recording is sometimes permitted with permission, but video is not. And so you really have to kind of think about another way of getting what you want. Maybe it's a transcript, maybe it's an audio recording, maybe it's something else. But that's why, we still have like courtroom artists for certain federal proceedings. Again, there's no First Amendment right to it, so there's not a whole lot we can do other than advocate that, as we usually do, that public access to what the courts are doing is very important. And the public is, in fact, very interested in what the courts are doing, and that's healthy and natural. But we'll get there. So let's turn over to yet another kind of related right to record topic, and this is of white-hot interest to people like me who deal with public records a lot. Let's go to the next slide, please, Kaylee. We're going to talk photography or videography of documents, which do not make for thrilling subjects of video, but that's okay. Sometimes what you're doing is you're taking a picture or a video in order to either prove the existence of the video to get B-roll or to save copying costs. You know that public records in Connecticut are sometimes viewed by especially towns as money-making opportunities. They view it as an imposition, and they think they should make money off of it, and they make 50 cents a page. So oftentimes they will want to charge you the 50 cents, but inspection under our law is free. That is to say, it's free to look at the document. That engenders the question of whether, when you are inspecting the document, you can take a picture of it with your phone or video for some reason if you want to do that. And this is an area in which there hasn't been a whole lot of progress in the last few years. That towns and cities are dead set against a rule that would allow people to take a photo of the document because it allows for effectively free copying of the document. Now, we the people probably think that's a great idea, but towns and cities are pretty powerful in the legislature, and they really want to make a buck off of public records. We have nothing in statute that addresses the question, but we do have an old provision for hand scanners. And I'm totally dating myself by asking, like, if you remember hand scanners, this was a thing in the 90s. You used to be able to buy these little scanners that were maybe about the size of like a mouse device. And you would rub them over the scan of the document and get yourself a scan of the document. So we have a provision in GS 1-212G that dates from those days that says if you pay $20, you can use a hand scanner effectively as much as you want. How that shakes out in practice today is that there are some towns and cities that view the hand scanner provision as applying to phones. And so they'll tell you, yeah, pay me $20 and you can take as many photos or videos of documents as you want. You've got some towns and cities that insist, they really want to make a buck, they insist the hand scanner provision applies only to hand scanners and not to phones. And then you've got some portion of the towns and cities that do not care at all and will happily let you take as many pictures as you want. You should send those towns and cities flowers because I think they've got it right? It doesn't cost them anything or hurt them if you just take pictures of what you're inspecting. Maybe this year I've heard that there are various moves afoot to try to update that, and that the towns and cities are insisting on a similar kind of $20 flat fee for for pictures of using a different device. I think that makes a lot of sense if you're bulk requesting, but if you're there for a copy of one document, nobody's going to pay $20 for that. It's a little unrealistic. Now, those are public records, so executive branch, legislative branch, towns and cities. Court records are slightly different. They're governed by a different set of laws. In our state courts here in Connecticut, most civil records are available online for free. It's a website that dates from, what seems to be the 90s. But it works okay. You can get most filings in civil cases going back about 10 years. So there really isn't a need for you to show up and inspect at the clerk's office. Criminal records, though, Connecticut has made again and again an affirmative choice to restrict electronic filing in criminal court. I think it benefits the prosecution hugely, and to restrict the public's access to criminal filings as a result. So if you're looking for a criminal record, you're kind of taking a express train back to the 70s. You will have to call the clerk's office at the court that holds the record. It's not centralized, and you have to go down there and ask them to get the record. And then I don't know what they're going to do about photography. As best I can recall, there's no rule on point. I suspect it's going to be a little bit like towns and cities, where some clerks are totally happy to just hold it up to the window and let you take a picture of it, and others will make you pay cash for whatever it is that you're looking for. It's just a little bit unsettled, unfortunately. In federal court, on the other hand, all filings, civil and criminal, are electronic. And PACER, I think these days, is 10 cents a page. So you can easily obtain those things online. If for some reason you're looking for something and you don't want to pay for it, even at 10 cents a page, each of the clerk's offices of the seats of court in Connecticut, we've got a U.S. District Court in Hartford, New Haven, and Bridgeport. Each of them operates, they have like a free terminal for PACER, and you can log in and look at stuff for free. I really don't know at that point. I think you would be photographing a monitor, because you would pull the document up on the monitor. I don't know that anyone would object to that. I also don't know if they have printing capabilities there. But because it's online and it's so comparatively cheap versus driving there, it tends not to arise very much. So maybe we should talk about our very last topic, and then we should hit questions. It's 11:27. I don't want to keep talking, which is what lawyers do way too much. So let's hit the last slide, which is public officials' right to privacy. This is sort of tied in with, and maybe I should have placed it back in the section where we talked about recording inside of buildings. So we talked a little bit about the privacy of what's going on in a government building, the privacy of the proceeding, a city council meeting versus a parent-teacher conference. Some of that is tied in with public officials' right to privacy generally. And the rules for them look a lot like they do for us. If they are out and about in a place that everyone can see them in, their ability to claim some kind of privacy interest in what they're doing is pretty diminished. That's not exactly true for people who are, especially a line level employee who works in an office. The office is not open to the public. That's a tougher call, as are situations in which the person's engaged in a non-public activity. Let's say your child's teacher teaching the kids. Some schools encourage parents to come in and visit. I very much doubt that you're going to be able to record what's going on in the classroom for a couple of reasons. One, the teacher has some leeway to do the job and speak to the kids without having to worry about being surveilled effectively. And two, there's other kids in the classroom, right? You don't want, the government's going to be pretty sensitive to disclosing their identity and allow them to being videoed. One thing is very clear, though, when it comes to recording, when it comes to records, is that the public employee's job performance is rarely, if ever, going to be a private matter. So if you're in the business of reporting on cities and towns or the state, the question of an employee who is disciplined, for example, that's rarely going to give rise to a privacy concern. We typically view the method or the manner in which an employee discharges their duties as fair game for us, the voters and the taxpayers. The records of that tend not to be private. But it may be the case that the employee is engaged in an activity that's kind of outside of public view, and you don't necessarily have the right to record.
Dan, we do have a couple questions in the chat, and the first one is, have glasses that can record, has that topic come up at all in terms of using them in these situations?
Not that I can think of from the case law. My own view is that the law would be the same regardless of the device you use. So whether it's a big, giant camera like the pros use for TV news, or whether it's glasses, I think it's going to be the same, because the question is not necessarily what you're using to make the memorialization. It's whether it's okay for you to record video at that time and place. I think the device is pretty immaterial.
Excellent, thank you. We've got another question. Somebody uses a transcription app for accessibility purposes. Is there any case in the law as it relates to the First Amendment and accessibility, anything around using those sort of transcription apps?
Not that I can think of, but in the context of someone needing an accommodation like that, or needing an assistance from software, I think it's going to be pretty hard for the government to claim that should be disallowed, so long as the person, as always, has a right to be there. So, for example, if I have this is on my mind, it's parent-teacher conference. If I have a parent-teacher conference, right, I'm the parent, I'm definitely allowed to be there, and I say, hey, because of a condition, I'm going to need an accommodation. Typically our laws are going to say that accommodation is appropriate. I think where I would be a little cautious is not to surreptitiously record. So if that's your accommodation that you need, okay to say, hey, look, this is the purpose of it. This is what I'm going to be doing, and that's that. I think you can understand that you might run into a problem if you effectively secretly record such an event and then later post the transcript online or something like that. But that's obviously outside of the realm of an accommodation. People rely on technology all the time. It ought not to be a problem.
Excellent, thank you. We have another question about how do the recording rules apply to political town committees? Are they public meetings? How do those situations work?
Oh, that's a great question. That is, I don't know if there's any case law directly on point. You're talking about like the DTCs and
Someone
stuff.
mentioned they cover the Democratic Town Committee and the Republican Town Committee, both of which generally meet at Town Hall.
Yes. That is, I say interesting, which is a code word for like, I'm not going to have a direct answer for you, but for the following reason. Number one, um, usually the law looks at the political parties as private entities. So, for example, I can create a political party and set my own criteria for who gets to be a member, right? You have to subscribe to my ideology, all that stuff. On the other hand, some of what they do is public. I think that you're probably on good footing if the meeting is open to the public, it's advertised, right? No matter what our recording question is, we go back to the first step and think, okay, am I allowed to be here? That's a pretty good indication. That's at least one indication. I'm allowed to be here. And then you kind of go through like, but is this private? I think if the meeting is advertised, anyone can come and sit and listen to them discuss. That's probably fair game for recording.
Excellent. Thank you for that one as well. Another question, are there any cases in Connecticut dealing with drone photography and this topic?
Oh, wow. I can think of a couple of drone cases, but nothing that's going to contest, let's say, the use of the drone itself. I think the law is going to go back to the question of whether the drone was in a spot that it was lawfully allowed to be. And you may know that we have some federal search and seizure case law about surveillance from aircraft that sort of turns on whether the aircraft was within the area that the FAA permits it to be. Now, drones, since they've become quite popular, have a subset of rules from the FAA about where they're allowed to be. And so long as that you're comporting with that and typically not using any kind of artificial enhancement. So, for example, you're allowed to fly over your neighborhood, but if you're dwelling over your neighbor's house and looking through the skylights, that may pose a problem. But I think it's going to be less device independent or less device dependent and more dependent on were you allowed to be there? What's the activity issue? So, for example, if I'm a reporter and I'm standing on the sidewalk and I'm watching the Hartford Fire Department respond to a huge blaze, I think that's fair game to say I can either, my camera person can be on the sidewalk with me, or maybe we fly a drone over as long as we're not interfering with the fire department in any way. It's effectively the same thing. It's just a different vantage point.
Excellent, thank you. And this seems to be my last question here. What to do if the police confiscate your cell phone that has recordings and photos to be used for a story?
Okay, call me. That's an interesting issue that I think is going to emerge. From my perspective as an ACLU litigator and an EFAC board member, after we the people began recording the police, let's say in the mid 2000s, they became very aggressive about finding ways around that right to record. And so there's a couple of games that they can play. Number one is, as they did to one of my clients that's in active litigation right now, they knew enough not to take his camera because he was on the sidewalk not doing anything. But instead, they demanded that he identify himself, and they kind of used that to bootstrap it into an arrest that they couldn't otherwise make. The arrest was still invalid. He didn't need to identify himself. But version number two is snatching cameras and saying, oh, they contain evidence, for example. So there's a couple of things you can do. The first is, I think I would, if you can, retain counsel because there's some moves you can make to immediately move for the return of property. In criminal cases, it's called the return of property. The second is to make an argument that the cops should not be able to search the entire phone, which you probably don't want. If you're like me, you've got personal information on there. I happen to have client data on my phone because I'm a lawyer, so you'd want to narrow their search, if at all. And the third is you want somebody to make an argument for our press shield law, that the cops really cannot be using the press as a source, absent certain extremely extenuating circumstances that typically that the journalist themselves was engaged in a crime and that the phone actually reflects that crime. That's never going to be the case. If you have that come up, give me a call. We can kind of talk through it, but there are ways of limiting the damage.
Excellent, Dan. Thank you so much for all this information and for this presentation. And many thanks to everybody that has been joining us today. And we provide these lessons as a public service to you. So please encourage your colleagues, encourage your friends to join us for future classes. And better yet, consider making a donation or becoming a sustaining member at nefac.org/support. On behalf of NEFAC, thank you so much, and we will see you next time.